जीअं त अॼु असां चैप्टर नंबर 39 पढ़ंदासीं ऑफ बेल, ज़मानत छा आहे ऐं ज़मानत जेको आहे कीअं अदालत खां मिलंदी आहे। जॾहिं FIR थींदी आहे त उन FIR में कहिड़ा कहिड़ा सेक्शन्स लॻंदा आहिनि, उन सेक्शन जो इहो मतिलबु हूंदो आहे त हिन जी जेको आहे हिन खे केतिरी सज़ा मिलंदी ऐं हिन खे जेको आहे त केतिरो बांड पे करिणो पवंदो। इन जे बारे में अॼु उहे कहिड़ा सेक्शन्स आहिनि जंहिंजी ज़मानत बेल ज़मानत थींदी आहे ऐं उहे कहिड़ा सेक्शन्स न आहिनि जंहिंजी ज़मानत न मिलंदी आहे। इन वाट केसिस बेल टू बी टेकन 496 CRPC आहे, चए थो त उहे कहिड़ा बेल आहे जेकी मिली सघे थी। चए थो वेन एनी पर्सन अदर देन अ पर्सन accused of a non-bailable offences is arrested or detained without warrant by an officer in charge of police stations or appears or is brought before a court and is prepared at any time while in the custody of such officer or at any stage of the proceeding before such a court to give the bail. Such a person shall be released on bail provided that such an officer of court, if he or it thinks fit, may, instead of taking a bail from such a person, discharge him on his executing a bond without sureties for his appearances as herein after provided further that nothing in this section shall be deemed to affect the provisions of section 170, subsection 4 or section 170 and subsection 3. Section 497 is amended by Code of Criminal Procedure Amendment Act 2011, 8 of 2011. 497 when bail may be taken in case of non-bailable offences. ज़मानत मिली सघे थी non-bailable offences में। चए थो when any person accused of non-bailable offences arrested or detained without warrant by an officer in charge of police station or appears or is brought before a court, he may be released on bail. But he shall not be so released if there appears reasonable ground for believing that he has been guilty of an offence punishable with death or imprisonment for life or imprisonment for 10 years. Provided that court may direct that any person under the age of 16 years or any woman, any sick or infirm person accused of such as offences be released on bail. Second, third and fourth provision is provided by Ordinance number 5 of 2010, omitted Act 8 of 2011, provided further that a person accused of an offence as aforesaid shall not be released on bail unless the prosecution has been given notice to show cause why he should not be so released. Provided further that the court shall accept where it is of the opinion that delay in the trial of the accused has been occasioned by an act or omissions of the accused or any other person acting on his behalf, direct that any person shall be released on bail, who being accused of any offences not punishable with death, has been detained for such offences for the continuous period exceeding 1 year, or in case of a woman exceeding 6 months and whose trial for such offences has not concluded, who being accused of an offence punishable with death and has been detained for such offences for continuous period exceeding 2 years, and in case of women exceeding 1 year and whose trial for such offences has not concluded. Provided further that the provisions of the foregoing proviso shall not apply to previously convicted offender for an offence punishable with death or imprisonment for life, or to person in the opinions of the court is hardened and discreet or dangerous criminal, or is accused of an act of terrorism punishable with death or imprisonment for life. If it appears to such officer or court in any time, any stage of the investigation, inquiry, trial, as the case may be, that there are no reasonable ground for believing that the accused has committed a non-bailable offence, but there are sufficient ground for further inquiry into his guilt, the accused shall, pending such inquiry, be released on bail at the discretion of such an officer or court, and the execution by him of a bond without sureties for his appearances as herein provided. An officer or court releasing any person on bail under subsection 1 or subsection 2 shall record in writing his or his reason for so doing. If at any time after the conclusion of the trial of person accused of a non-bailable offences and before a judgment is delivered, the court is of opinion that there are reasonable ground for believing that the accused is not guilty of any such offences, it shall release the accused if he is in the custody on the execution by him of a bond without sureties for his appearances to hear the judgment delivered. A high court or court of session, and in the case of person released by itself by other court, may cause any person who has been released under this section to be arrested and may commit him to custody. उन खां पोइ जेको आहे असांजो 498 जेको CRPC आहे, पावर टू डायरेक्ट एडमिशन टू बेल और रिडक्शंस ऑफ बेल. The amount of every bond executed under chapter shall be fixed with due regard to the circumstance of the cases and shall not be excessive, and the High Court or Court of Session may in any case whether there be an appeal on conviction or not direct that any person be admitted to bail, that the bail required by police officer or magistrate be reduced. 498 no bail to be granted to a person not in custody in court or against it whom no case is registered. Nothing in section 497 or section 498 shall be deemed to authorize the court to release on the bail or to direct to be admitted to bail any person who is not or is not present in court or against whom no case is still registered for the time being, and in order for the release of a person on bail. Direction that a person be admitted to bail shall be effective only in respect of the case that so stands registered against him and specified in the order for direction. 499 में bond of accused and sureties. Before any person is released on bail or released on his own bond, a bond for such sum of money is the police officer or court as the case may be, thinks sufficient shall be executed for such a person. When he is released on bail by one or more sufficient sureties, conditions that such a person shall attend at the time and place mentioned in the bond and shall continue so to attend until otherwise directed by police officer or the court as the case may be. If the case so requires, the bond shall also bind the person released on bail to appear when called upon at the High Court, Court of the Session or other court to answer the charge. इन सेक्शन में असां CRPC में पढ़ंदा आहियूं त ज़मानत माण्हूअ खे कीअं मिले ऐं जेकॾहिं ज़मानत ॾियणी आहे त उन में बांड जो रेशोज़ घणो हुजे, घणी श्योरिटीज़ जेको आहे त जेको अक्यूज़ पर्सन आहे उनखे रिलीज़ करण जे लाइ उनखे अक्यूटल करण जे लाइ केतिरी श्योरिटीज़ जमा कराइणी पवंदी आहे. सो हिन चैप्टर जो मक़सदु ई असांजी ज़मानत आहे, बेल आहे, चैप्टर जो नालो ई. ऐं उन खां पोइ जेको आहे असांजो जेको आहे 400 पढ़ंदासीं असां जेको आहे until other direct police officer if the case so require, the bond shall also bind the person released on bail to appear when called upon at the High Court and Court of Session other concerned the charge.